Well, good morning, everybody. The second time, welcome to the TMH Stallard employment webinar. Today is the first of a two-parter relating to trade unions. So in terms of what we're going to be covering this morning, we've first of all have a brief introduction and context from Will, my partner, Will Walsh, and then Stephen Tenhove, another of my partners in the employment team. We'll just give a brief history of trade unions, and as well as being interesting, I think it's actually also quite important just to consider how trade unions came about, and that helps you understand how the law interacts, as it were, with trade unions. We'll then go on, we'll look at types of recognition agreement, and Stephen will then come back and run us through some of the key stages of the recognition process. We then have a scenario for you where we've got some questions, and we'll work through that. And then we'll finish off. I'll just cover some of the key individual employment rights that trade union members have. Just a couple of housekeeping points. Just a reminder, please, that if you've got any questions as we go, please can you put them in the Q&A function. And if you've got any technical problems or issues, you can't hear us or see us, which some would say would be a blessing, if you put those, please, in the chat function. We'll probably run for about 55 minutes or so this morning, should finish around about 10:30. We've got a couple of poll questions as we go through. It's all anonymous, so don't worry, no one's going to come back and interrogate you, but hopefully you'll get a fair amount of information this morning and also some thought-provoking ideas. So if I may, I'll hand over now to Will.
Many thanks, Rustam. So yes, I'm just going to start off with a very general overview and just give an idea of the recent trends in trade union membership patterns, which will hopefully give you a bit of context and also the opportunity to give a bit of an assessment about the likelihood of you facing either industrial action issues or indeed trade union membership recognition requests going forward. So starting off, potentially, depending on which side of the fence you're sitting on, the overall good news, I guess, is that in recent years, there has been a downward trend in trade union membership. So in the graphic that we've got on the screen there, it goes all the way back to the 1800s, when trade unions were first formed. And we can see a fairly steady rise over the years, which hit an absolute peak in the late 70s, early 80s. So that's the highest level of trade union membership. There's been a fairly steady decline since then, a little bit of an uptick. You can just see on the graph there in around about the early 90s, and it's been continuing to dip downwards beyond there. And membership decreased to 23.1% in 2021. So far so good. And you might think, okay, great, we can all switch off now, not something to worry about. However, if we look at the next slide, which just seems to have frozen just a second, but I'll start to talk to you about that. Basically, here we go. Past membership peaks have tended to match periods of particular discontent in years gone by. So a little bit of the graphic is hidden there, but there we go. So this doesn't show us going back all the way to the 1800s, but does show us the pattern from the late 70s onwards. And actually that pattern on this graph, this particular one shows inflation rates, which is obviously just one of the factors, but it's interesting to see how it matches compared to everything else. So again, as you remember from the previous graph, we had the maximum trade union membership in the late 70s, early 80s, and look, and there we go again on this particular graph, an absolute peak in inflation rates exactly the same time. We've then had a steady decline in inflation rates, a brief uptick in the early 90s. So again, that matches the same pattern that we had in the trade union membership, with a slight increase at that point and a gradual decline since then. But then, of course, we get to 2022. And as we all know, inflation is very much on the rise currently, with a significant rise in recent times, up to current 9%. possibly with that going higher in the future. And then obviously added to that with general issues around cost of living, energy prices, all the things that we know all too well about, quite possibly leading to what some have described as being a winter of discontent. And again, with those periods of particular discontent, that's when trade union membership trends have gone up. Added to that, in terms of the information we've had from the unions themselves, the TUC themselves have reported a 700% increase in visitors to its Find a Union webpage, an indicator in itself. GMB, comparing October 2021 to March 2022 versus the same period in 2019-2020, have seen again a 700% increase in the number of employed disputes it's been involved with. Unite have seen a 400% increase in disputes, and again, been very well publicised in the press, the number of high-profile industrial action, and indeed many of you will have experienced it firsthand in terms of disruption. So we've had British Airways, BT have had their first industrial action since 1980 when they were privatised. Very recently, Royal Mail, as we all know, the rail services, post office, and so on. So there's definitely been more and more in the press, and again, historically, a lot of industrial action has been in the public sector, but more things spilling into the private sector now as well in terms of those general trends. And again, other things that have been in the press: Ryanair, Deliveroo, Uber. These are all companies which that they would never reckon. All of those now, lo and behold, are in discussion at the moment about trade union recognition. So there's definitely that upward trend. So I think it's not too far a leap to speculate that the likelihood of trade union recognition is on the rise. It could be something that you are faced with, and if it is, well, what could the impact be? In broad terms, first of all, there is the increased likelihood of receiving recognition requests from trade unions. And then hand in hand with that, requests for recognising trade unions for collective bargaining. And we'll talk about what that means in a bit more detail in a bit. And then, of course, the one that hits the headlines, industrial action as well. So increased trade union activity or membership could increase the risk of industrial action as well. In terms of what that looks like, we're going to be covering that in more detail in our second webinar on this point. But in general terms, strikes, those are things that we think about first and foremost when we think of industrial action, so staff going on strike. But there's also what we call action short of strike. So it's not staff not turning up to work, but there are other things that can be done within the remit of industrial action, such as working to rule overtime bans, withdrawal of cooperation. And effectively what this means is that the employees still stick to their employment contracts, but they stick to them very rigidly. So all those bits around the edges where you might normally require extra flexibility, that disappears. So employees will turn up. If their contract says that they need to work 9 to 5, they will arrive at 9 o'clock, they will leave at 5 o'clock on the dot. If you normally expect a bit of flexibility around duties and covering other people's duties, that won't happen. Employees will do their duties as described under their employment contract and nothing more. So there are ways of being disruptive, but within the scope of their employment contract. And again, that falls within that remit. So before we move on to Stephen's section, we have a poll question for you to vote on. There's a fair bit for me to read on, but you can kind of start to have a look yourself and start to vote while I'm going through it. But what we're asking for is just to get a general sense of which of these best describes your own organisation at the moment in terms of trade union membership and indeed trade union recognition. So we've kind of got the full range, the broad spectrum from top to bottom. So that at the top, we've got those who have trade union members at the moment in your own workforce and also have trade union recognition in place right now. Second one, you've got trade union members, you don't have formal recognition, but you believe that might follow soon. Third one is you have got trade union members, but you don't believe you're likely to receive a request for formal recognition from a trade union itself. Fourth down the list, you don't have trade union members at the moment, but you think that's likely to change in the next 12 months. And then obviously bottom end of the scale, you don't have trade union members at the moment, and you don't expect any to appear in your workforce in the next 12 months either. So if you just take a moment just to sort of click on the one that you think sort of fits your organisation best at the moment, and we'll just see what the results are. Fine, okay. So we've got a good number, over half, that do already have members and recognition in place, which is interesting. And again, I'm not sure how many of those recognition agreements are historic or relatively new, but I suspect there will probably be at least some that fit within that pattern of increased activity. And then we've got various people in the middle there as well. Okay, that's interesting, good to know. So at this point, I'm going to pass over to Stephen, who is going to give us a bit of general background and a history of trade unions.
Thanks very much, Will. When we decided to do these two talks on trade unions, we thought that it would be interesting and useful simply to have a background as to where trade unions came from and where they may be going to. So I think we can start with the very fundamental question with what is a union? And there is a statutory definition of a union in the 1992 Tulcra Act, but I'd like to put it as an association which seeks to achieve better pay and working conditions for its members by collective rather than individual negotiation and/or action. And modern trade unions began as workers' associations in the early 19th century. And by an association, I mean no more than the way in which people organize a football club or a tennis club, a simple unincorporated association of people. And they were formed to address the imbalance of bargaining power, which may exist to this day between an individual worker and an individual employer, by instead having collective bargaining and collective withdrawal of labour should the workers not get what they demand. And the key point, I think, about all of labour law in Britain is that, broadly speaking, there's no constitutional right to association or a right to strike. So the rights that you have are governed by statute or the development of the common law case by case. So in the early 19th century, for example, such associations, labour associations, were subject to the criminal law of conspiracy and the civil laws of restraining trade and interfering with business by unlawful means, essentially people conspiring together to persuade people to break their contracts with their employers. And indeed, it took until about the early 1870s before trade unions were put on a legal footing, and they were put on a legal footing by statute, the Trade Union Act 1871, which was the first time trade unions were recognized as lawful associations as opposed to unlawful conspiracies. And at the same time, there was an act also passed in 1871 which exempted trade unions from the criminal law. But the judges had difficulties with reconciling trade unions as lawful associations and their job to persuade people to break their contracts of employment, because they tend to look at things, legal matters, as being contracts between individuals, an individual employer, an individual worker. And so it took them a long time to get used to the idea of trade unions as lawful associations, and in particular in two cases in 1901, the Taff Valley Railway case and Quinn and Leatham. The House of Lords held that unions were liable for losses of employers during strikes and liable for losses if employees were to put pressure through unions on employers. But of course, this effectively makes striking unviable, because if you're going to be liable for the damages of the employer, you're going to be out of business as an association before you begin. So the Trade Disputes Act 1906 was passed to give trade unions immunity from liability in tort if the action was taken in contemplation of or furtherance of an industrial dispute. Now, be careful, if it falls outside that definition, then it would still be unlawful. And this remains broadly the position to this very day. if the action the trade union is contemplating or the industrial dispute they're contemplating is lawful, then they will be immune from suit. But if it's unlawful and it doesn't fall within the definition, then it will be it'll be unlawful. And there's a neat example of this to the present day of something that remains unlawful, and that is that the police and the armed forces are prohibited from taking industrial action, and it remains a criminal offence to induce police officers and members of the armed forces to take such action. So the armed forces and the police are in the situation that most workers were in the early 19th century, which I find quite interesting. So during the 20th century, the unions exercised their industrial muscle increasingly, immune as they were from legal action. And it was believed by the late 1960s that they were abusing their position. And both the Labour and the Conservative governments at the time attempted to deal with that situation, but neither succeeded. And in 1974, the then Labour government agreed with the unions that it would strengthen the legal rights of unions further, provided the unions cooperated with the government's economic policy. And it would also strengthen the legal rights of individual employees, consolidating and passing what was then the Employment Protection Consolidation Act of 1978, which is now the Employment Rights Act 1996. And this development of individual rights, I think, is very important for a historical view of labour relations. We then go on to the Thatcher government, who bit by bit outlawed things like secondary picketing. That's people picketing at premises that are not the employer's premises. It insisted on secret ballots for strike action rather than mass groups of people voting. If you broke the law, your assets were liable to seizure as a union. Next slide, please. And very gradually, the laws that unions had to operate within were tightened. And this was eventually consolidated in the Trade Union and Labour Relations Consolidation Act 1992, TOLCRA, which of course is still with us today and is the structure under which trade unions operate to this day in this country. Indeed, it defines what a trade union is in section 1, and it goes on to explain how trade unions are going to operate. Interestingly, it's never been revised by any subsequent Labour government in a major way, and certainly not revoked. And what we've had under the Conservatives in the last 12 years is a gradual tightening of things like the ballot requirements for strike action. And they're particularly tight now in the public sector where vital services are concerned. So that's where we've got to at the moment. Where are we likely to go to in the future? Well, I think that one of the issues that the unions now deal with is that under the Employment Rights Act 1996, workers pursue their individual rights rather than their collective rights. So they need unions less because they have effective individual legal rights, which they can enforce in tribunals. Unions have also suffered in recent years from globalization, manufacturing in particular. So the original heartland of union activity in manufacturing has gone abroad, and the economy has largely shifted to services which tend to be carried out in much smaller groups, except in the public services. Workers demand flexibility these days as much as employers do. And again, this is an issue of individual rights rather than collective rights. But that said, I find the unions, many unions, very, very canny in the way that they use internet and social media to publicize injustice and to attempt to recruit new people. Interestingly, trade unions have been very, very good at sponsoring individual legal action. The laws to do with 0 hours, workers' status, employment tribunal fees, these are all Supreme Court cases, all successful and all sponsored by unions. It's very good for their reputation. It makes them look constructive, and it's very good for union recruitment as well. Employers like to lobby the government. trade unions like to lobby the government as well. So they remain a very effective lobbying force, I think, not only at government, but also on the radio and on the television as well. But as a sort of counterbalance to what Will was saying a little bit earlier, in 2020, terms and conditions decided under collective agreements covered only 13.6% of the private sector, but 57.2% of the public sector. But of course, the public sector is much smaller than the private sector. So that's me done with a brief whistle through of unions past and future. And now Will's going to go on to the types of recognition agreement.
Many thanks, Stephen. So yes, so in this next section, I'm just going to give you a brief overview of the different types of recognition agreements that could be put in place. So if you were to be approached by a trade union, what does that actually look like in terms of what the end result could be? There are effectively three different types of recognition agreement I'm going to run through. The first one being what we call voluntary recognition. So this falls completely outside of any statutory scheme or process. And effectively, it is exactly as described. It is voluntary recognition. So the union would make a direct approach to the employer, so not part of a formal statutory request or anything like that. It simply approaches the employer and asks or puts in the request to be recognised by that employer. And then it is then open to the employer and the union to agree recognition on an entirely voluntary basis. The advantage of doing it this way, on both sides, in fact, is that it does give complete flexibility on the scope of recognition. So what I mean by that is that you could, at one end of the scale, simply agree to recognise a union, but not necessarily agree to recognise it to carry out collective bargaining on behalf of your employees or groups of your employees. You could simply recognise it and agree a scope of things that you will perhaps consult within or notify about, or allow certain access to employees and so forth, without going fully into collective bargaining as well. However, that's fairly rare. Normally, there would be at least some degree of collective bargaining agreed, so that the union would be recognised as the body that you would go to when you are consulting with staff about terms and conditions of employment or changes to those things, for example. But again, the flexibility is there in terms of the subject matter, about the exact things that will form part of the recognition agreement and what the union will or won't be recognised for. And there's also flexibility around the termination provisions. As we'll see in a moment, under the statutory scheme, that becomes a bit more rigid, but in an entirely voluntary recognition arrangement, it would be fairly typical for the union and the employer to agree, for example, a 3-month notice period for either side to end that particular agreement. So that's one end of the scale, an entirely voluntary recognition. Somewhere in between, we get what we call semi-voluntary recognition. And effectively what this means here is it may be that the union started off by asking for entirely voluntary recognition and didn't necessarily get the result it wanted. That's reasonably common. So what happens next is the union makes a formal recognition request under the statutory process. So it starts off that statutory process, and Stephen's going to talk to you in just a moment about what that looks like and what the steps are. So we're in the, once that's happened, we are now covered by the statutory regime, but there is then a period of time where the union and the employer will look to reach agreement on recognition within a set period. And again, Stephen will talk to you about what that looks like in just a moment. If they can reach agreement on these things, then the union would be recognised as entitled to conduct collective bargaining on behalf of a group of employees. So it would be employer and the union to agree with covered by the recognition agreement and for the recognition as well. Starting point under a statutory scheme is that collective bargaining will cover pay, hours and holidays. However, you can agree additional areas if you want to. As mentioned just before, the termination provisions do become a little bit more rigid now that we're into the statutory or semi-statutory scheme. And basically what that means is that a semi-voluntary recognition agreement can be terminated by the union at any time, but on the employer side, unless otherwise agreed, the employer can't terminate for the first 3 years. Once that 3-year period has elapsed, the employer has then got flexibility to terminate with or without consent. So then the final type is that if the parties are unable to agree voluntary recognition of any kind, then it's up to the union, if they wish to do so, to apply to the CAC, the Central Arbitration Committee for formal recognition. And the CAC will consider the application. It won't necessarily grant it, if there are various factors it will bear in mind. And the union must convince the CAC that it will have minimum support levels amongst staff as part of that process. If, again, once the first thing the CAC would do would be to, if it were to do so, would agree to the application for voluntary recognition. But then again, there is still scope for the employer and the union to agree what the bargaining unit will be, in other words, which group of employees will be covered, and also how collective bargaining will take place. But again, if those things can't be agreed on, then the CAC has got the power to make those determinations itself. So the fallback default position is the CAC will determine which employees will be covered. And again, the CAC can, if nothing else is agreed, impose a default method for collective bargaining on pay, hours, and holidays. And what that default method looks like is that they will agree, or they'll put in place a mandatory joint negotiating board, and there'll be clear rules about how many individuals on each side, on the employer side and on the union side, will make up the negotiating board, how long people sit, who will be the chair of meetings, the timings of meetings, the facilities the employer has to put in place to manage those meetings and allow access for the unions. And then there'll be a 6-step bargaining process set out. So in terms of a formal set process in terms of proposals, meetings, counter proposals, and so on. So it all becomes pretty rigid and set in stone. I have to say that that last bit is pretty rare. Normally, once you get to the point of the CAC saying there will be recognition, then more often than not, the employer and the union will agree on the mechanism past that point. But again, there is that default method, which again becomes the most rigid of all. So I'm just going to pass back to Stephen at this point, who is going to run through a bit more detail about the recognition process and the key stages about how recognition can be put in place.
Thank you, Will. I regret that there's no interesting way of doing this. The 1992 Act applies, it's very rigid, and the steps are what they are. So I'm going to go through them, plow on, and I hope you'll stay with me for the next 5 minutes while I do. A union initially makes a request for recognition by an employer. The request must be made in writing. It must identify the relevant union or unions. There's no reason why a joint request can't be made. It must identify what the union thinks is the relevant bargaining unit to which the collective agreement will apply. It must state that it's made under TOLCRA 1992 Schedule A1. And also the employer must be shown to have received the request. There's a remarkable amount of case law on when the employer has or has not received the request. Those are the crucial things if you want to make a request. On receipt of a request, the employer may agree to the request, as Will has said, which it must do within 10 days. And if it does so, then we have an agreement, and that's the end of the matter. The union is recognized. If the employer doesn't agree to the request, but agrees to negotiate, then they'll be deemed to be recognized if the parties agree within the next 20 days. And ACAS assistance may be requested to achieve this. And it's a very sensible idea if you are the employer to get ACAS to agree to assist you. Note, it's always possible for both employer and union to come to a voluntary agreement outside TOLCRA altogether. Will touched on that. So you can just agree without a formal request from the union. If the employer fails to respond to the request at all within 10 days, or to negotiate, or negotiations break down in the next 20 days, the union may apply to the Central Arbitration Committee, CAC, to determine the appropriate bargaining unit, and if the union has the support of the majority of workers within that unit, or if the parties have agreed that the union does have the support on the appropriate bargaining unit. Note, the union may not apply to CAC if it has rejected or failed to respond to a proposal from the employer that ACAS be requested to assist with negotiations, which is why I say the employer should use ACAS, because it slows the process down, gives you more time to think and more time to negotiate with the union. The union's application to the CAC must cover workers and must concern a legal employer. So the union needs to be clear about who it is applying over, on whose behalf it's applying and who the employer is. And the application must be in the form prescribed by the CAC, but that's not difficult because it's on the CAC's website. The union must notify the employer that it's applying to the CAC, together with a copy of its application and the documents supporting it. It's vital that the application includes a description of the bargaining unit, but that description doesn't need to be precise. The employer simply needs to understand what it refers to. The CAC must reject the application as being inadmissible unless it decides that members of the union make up at least 10% of the workers in the relevant bargaining unit, and a majority of the workers in the bargaining unit would be likely to favour recognition of the union to conduct collective bargaining on their behalf. The first is precise, the second is less precise. The CAC will not accept competing applications for recognition by rival unions, but don't confuse this, as I said earlier, with a joint claim for recognition on behalf of two unions. Once the CAC has accepted an application, it will give notice that it has done so to the employer, who must within 5 days, so it's very quick, provide the CAC and the union with the following information: a list of the categories of workers in the proposed bargaining unit, a list of the workplaces at which the workers in the bargaining unit work, and the number of workers the employer reasonably believes to be in that category, in each category in that workplace. So you've got a lot of work to do as the employer as soon as you receive an application from a union. So when you get the informal application before the union has applied to the CAC, start your work on these things first on the assumption that you will be referred to the CAC in due course. What is the appropriate bargaining unit? The employer and trade union may agree. If they don't, the union proposes a bargaining unit, and if the CAC finds the unit is not appropriate, it must go on to decide one that is. The primary consideration for the CAC is the need for the unit to be compatible with effective management. But what effective management is depends on the views of both the employer and union. And as Will has said, if agreement can't be reached, the CAC simply imposes a very detailed solution on the parties. If the bargaining unit is selected as different from that which the union proposed, the union must confirm that its application complies with certain validity provisions. Once the bargaining unit has been agreed or decided, the CAC then proceeds to decide on whether it should issue a declaration that the union is recognised. So bargaining unit first, recognition second. It can grant recognition without a ballot if it's satisfied the majority of its workers in the bargaining units and members of the unions. There are some exceptions to this. Where the CAC concludes the majority of workers are not in the union, it will arrange a secret ballot in which the workers in the bargaining unit will be asked whether they wish to be recognised or not. To win the secret ballot, the union needs to obtain the support of both the majority of the workers voting and at least 40% of the workers constituting the bargaining unit. So a union will think about that right at the very beginning of the process when it looks at the bargaining unit it's proposing. Will it have the chance of getting a majority of workers voting? will it have the chance of getting at least 40% of the workers constituting the bargaining unit voting for the proposal? If the union is unsuccessful in the ballot, the CAC will issue a declaration that it's not entitled to be recognised. And that declaration bars the union from making another application for a further 3 years. So that's all pretty dull, cut and dried. But now I'm pleased to say Will has a scenario which is much more entertaining, which we're each going to comment on. So back to you, Will.
Many thanks, Stephen. So, yeah, as Stephen says, we've put together a basic scenario just to try to tease out some more important issues. So I'm going to sort of set the background for what our scenario is. So starting off with our company, we've got, the boss here. We've got Ernst Stavro Blofeld, and he is the CEO of Spectre Limited. In terms of his business itself, well, they're right in the middle of constructing a large underground base hidden inside an inactive volcano. From there, the business plan is they're going to launch a rocket to space equipped with a laser satellite. They're then going to require a payment of £10 billion from each nuclear superpower country under the threat that the space laser will destroy the weapon stockpiles of those who refuse to pay. So that's the business plan. It's a large company, lots of workers, and they're split into 4 main divisions. We have the science division that's headed up by Dr. Julius No. Dr. Kananga is the head of engineering. Then we have Jaws, director of construction, and then finally head of security, Rosa Klebb. And those 4, together with Blofeld, make up the senior management team. Now, there's a few problems in the workforce. So the first issue is that all workers are paid low basic salaries, with some just on national minimum wage. But the incentive for them is that they've all been promised bonus payments on successful completion of the extortion. And the amount that each person gets will be based on net profits from that extortion process. The workers are becoming increasingly disgruntled, and they're worried about cost of living. The project's going to be a long one. It's not going to be completed for at least a year, and they've got the winter to get through: inflation, rising costs, energy bills, and all the rest. They've got to pay their bills in the meantime. At the same time, they're also a bit worried about what's going to happen at the end. They realise that their big payout, the bonus, is linked to profits, and those themselves are likely to be hit by the cost of building materials going up, the cost of rocket fuel going up, and the enormous energy cost to heat and power a volcano base, particularly with this oversized piranha pool that has to be maintained at a constant 28 degrees. So the more that gets used up on those things, the lower the profits, the less money they're going to get out at the end. In addition to that, scientists who are freelance workers have all been declined all paid leave for the past 6 months while they work on the plans. Security are unhappy with the number of night shifts that each worker has to do, particularly with the increased risk of attack from spies during the hours of darkness. They've got some further concerns outside their contract as well, and they're particularly worried about Spectre's disciplinary policy, which effectively reads: stage 1, invitation to meeting; stage 2, Blofeld makes a decision; possible outcome, ejection into piranha pool. So, in the background, 007 has managed to infiltrate Spectre. She has identified an opportunity to stall Blofeld's plans by helping the workforce push their complaints forward. She's encouraged a number of them to join her trade union, Work Without Bonds. Work Without Bonds make a request to Spectre for recognition, allowing them to undertake collective bargaining on behalf of all workers at all levels in respect of all matters relating to pay, hours and holiday, plus the ability to negotiate on all other contractual terms and on non-contractual company policy as well. So the request covers pretty much everything. So, poll question for you, and actually probably helpfully a number of you from our first poll scene have already been through this type of process, recognition request process in the past. So you may have a bit of extra inside knowledge on these things, which may help us. But general question, there's no right or wrong answers. But if you were in Blofeld's position and you've received a request from Work Without Bonds for recognition, which of these factors might worry you the most? I just pick one of these. So the first one, a very broad one, would the prospect of having any trade union recognition at all be top of your list of concerns? Or would it be the fact that the request is looking to cover all members of staff at all levels of seniority rather than a more specific group of employees? Would that be your main concern? Or indeed, is it the last one, the fact that the request is looking to cover all matters, so all contract terms, not just pay, hours, holiday, but all contractual matters and non-contractual policies as well? So just out of interest, which would be sort of top of your list of concerns if you were in Blofeld's shoes? Got the last few people sort of keying in their responses. So yeah, actually, yeah, quite a nice, fairly even split actually. So bang on 27% each for trade union voluntary recognition or trade union recognition at all, and then the number of staff get the equal number of votes. And then, but again, I think it's probably the one that just has the majority in terms of concerns is the subject matter for consultation, covering pretty much everything under the sun, being the main one. Okay, so what we're going to do is we're going to sort of just dig into a bit more detail, pretty much on those three questions. So I'm going to sort of take the first one there. So should Spectre agree to voluntary recognition? So at the moment, it's not part of a statutory request. They Work Without Bonds have asked for completely voluntary recognition. Should they agree to it? Well, I think probably the best way to look at this, I mean, again, the full answer is pretty detailed, but just picking out a few highlights. I think the way to look at it is, to start off as a starting point, what would they actually gain by rejecting the request for voluntary recognition? Well, if you're worried about having any recognition in place, then agreeing to voluntary recognition is possibly a bad idea. And you may feel that the numbers could stack up on your side. So if you were to reject voluntary recognition, as Stephen's mentioned just now, you need to have minimum levels of support if you're going to push through something through the CAC. And you may be confident that, that those thresholds won't be met, and therefore you can escape recognition altogether. So I guess that's one possible factor for Blofeld to bear in mind. There are a couple of other things as well, is that if he's worried about that particular union, Work Without Bonds, there might be other things that he may be able to do to appease the workforce in other ways. So a number of our clients, for example, who have historically been concerned or against the idea of formal trade union recognition, have put in effective internal staff consultation bodies, for example, so that they still give their employees a voice internally, but it's not through formal trade union recognition. So perhaps something like that could be something that Blofeld could propose to his workforce, possibly getting a little bit late in the day in terms of if he hasn't done that before, then trying to put that type of mechanism in place where there's already momentum behind trade union recognition, but nevertheless, it's something that could be considered. And an alternative, a variation on that, of course, is that another way to defeat, if he was particularly worried about that union, Work Without Bonds, but actually felt that there was another trade union there that he might feel that might be more favourable to listening to his own concerns, because indeed, it's not always necessarily a downside. There can be plenty of positives to having formal trade union recognition. Apart from anything else, it can help to consult in some circumstances with a trade union body rather than having to do the same exercise with your entire workforce, potentially on an individual basis. So if Blofeld felt that there was another union that he might consider more favourable, then a way to defeat an application for recognition will be if you have an alternative union that you do recognise. So a recognition agreement in place with another trade union will defeat an application from a different trade union. So again, that's something that Blofeld could potentially explore as to whether you can muster some support for recognition via a different union. But the other things, again, for Blofeld to bear in mind, of course, is that, you know, as per my last section, if you are resigned to the fact that recognition of some kind is likely to take place, or indeed you see that there's a benefit of having recognition with a union of some kind, then actually the voluntary process is the better out of all of them, because it just gives that extra degree of flexibility, rather than being stuck with the much more rigid CAC determinations. At the moment, he's got that opportunity to whittle down particular areas of concern and hopefully find that common ground. Of course, whether he finds that common ground will depend on the union as well, and in terms of how flexible work without bonds is prepared to be in terms of its list of demands. But of course, once you've started discussing voluntary recognition, you're not duty bound to follow it through. It might be that you try to find that common ground, and if it becomes impossible, then you say this is not going to be possible, and then of course it's up to the union to decide whether or not it wishes to pursue a formal statutory application or not. So I think those are really the key points in terms of voluntary recognition and the things that Blofeld should be thinking about in that respect.
I'm going to deal with the bargaining unit, which I'll deal with fairly briefly, but I think the key issue for the union when proposing a bargaining unit is to keep in mind the factors that are relevant to it, but they need to make sure that they have the voting goes their way. So they need to be very careful in examining the workforce to make sure that they have the necessary votes that will be required to vote through whatever proposal CAC comes to in the end. And there are a couple of other problems that they will have in defining the bargaining unit as well. The scientists who are working on it are said to be freelancers. So we'll have to be very careful as to what their worker status is, because if they are truly self-employed professionals, then they will be cut out of the bargaining unit altogether, and that may alter the balance as to whether there can be effective management of the bargaining unit as a whole. But I think the union should propose that the bargaining unit should be the workforce as a whole subject to those things, because it's undergoing a single project defined in time, and I think that it all hangs together. The most important thing is, can there be an effective management of the bargaining unit from both the employer and the employee's perspective? And I would say that the unit as a whole is what the union should go for. If Blofeld wishes to oppose this, of course, he'll say that he can't effectively manage bits that are entirely unionized, but I think he's likely to be unsuccessful at that, because it seems to me it operates as a whole unit. One of the other factors that will be taken into account by CAC is the existing bargaining units in other national industries similar to Spectre, but unfortunately I don't think that's going to be much help in this case, because I don't think there are many other UK entities who do the sort of thing that Spectre does. One of the other things that the CAC will take into account is whether how they can avoid small fragmentary bargaining units. And again, that's another argument in favour of having the workforce as a whole included in the bargaining unit. Again, the location of workers is also an important factor. Again, I think that goes in favour of having the bargaining unit as the entire operation, the entire Spectre operation, as opposed to one or two bits. And so if I were Blofeld, I would try and divide and rule, but I don't think as a strategy that will be successful when it comes to the bargaining unit itself.
Thanks, Stephen. I think then I'm just picking up the final one. Which particular areas might we include as matters for collective bargaining? Well, as Will flagged on one of his previous slides, the kind of core are sort of pay, benefits and holidays. And so from the employer perspective, you would want to limit it as closely to that as you can. from the union perspective, they may well be trying to extend it into other contractual policies, or indeed certain non-contractual policies, the most obvious of which, the most common of which would be a redundancy policy, which usually isn't contractual, but which will nearly always be something that the union will want to not just be consulted upon, but be negotiated with upon. So just moving on, looking at the individual employment rights of trade union members, it's first of all important just to recognise and appreciate that trade union members will have rights both against their trade union as members of that association or organisation, as well as rights against their employer. And it's that latter category that I'm going to just focus on this morning. So the key areas are, starting as it were at the top, is it's unlawful to refuse someone employment because they are or are not a trade union member, or because they're not willing to become or remain one. And it's very often the approach of the law in the UK to trade unions, trade union membership, is the idea it's all voluntarist. So you can choose to be a union member if you want to be, and there shouldn't be an impact on you, negative impact as a result. You can choose not to be a trade union member, and yet you should still be able to work. There's also broadly equivalent provisions in the context of job advertisements and employment agencies when they're looking to recruit and hire. The key exception to this are those who are genuinely self-employed. And hopefully you'll have picked up from what we've been saying this morning that most of the trade union legislation, both at a collective level and at an individual level, doesn't just relate to employees, it relates to that intermediate category of worker as well. Indeed, most of the legislation talks about workers. Next area is what's commonly referred to as blacklisting, and that would be a list of those involved in trade union activities. And it's a prohibited act to maintain a list which contains details of trade unions or persons who've taken part in trade union activities with a view to, and that's really important, that list being used by employers or employment agencies for the purposes of discrimination in relation to the recruitment or treatment of workers. And this piece of legislation came about following a practice which was fairly widespread in relation particularly to the construction industry, whereby these lists were maintained. So that's been outlawed. When we look at inducements, and the legislation around trade unions and members often talks about inducements, a slightly quaint and old-fashioned term, but there are limits on the employer where the employer is seeking to induce a worker to do certain things. And there are two main areas here. The first is that the employer must not make an offer to a worker where the sole or main purpose of making that offer is to induce or encourage an individual to become, or rather not to become, a member of an independent trade union, not to take part in its activities, or indeed, as I say, to become a member of the union. So the employer is not, as it were, able to say, you know, you'll get extra money, you'll get an extra bonus if you agree not to be a trade union, not become a member of the trade union, or indeed, if the reverse is were the case. The other area around inducements, which is really key, particularly to appreciate once you have recognised a trade union and where terms and conditions are established through collective bargaining, is that basically the employer cannot go around above the heads, if you like, of the trade union and try and seek to agree terms on an individual basis with an individual employee. So it's prohibited for an employer to induce a worker who's a member of that independent trade union where the union is recognised by the employer. It's prohibited to make an offer where the purpose of it or effect of that offer would be that the terms and conditions of employment of that individual are no longer determined by the collective agreement. There's been quite a lot of recent litigation around this as to precisely what that means, particularly in the context of no longer determined by, whether that's a one-off instance or whether that's forevermore. But it is, as I say, a pretty detailed area, and it's one that a lot of employers are potentially caught out by. We then look at dismissal on the ground of trade union membership or non-membership or activities. Again, law seeks to approach this in what some would say is an even-handed way, some would say is slightly out of context way in the context of trade unions and how they operate. But in any event, it will be automatically unfair to dismiss an individual because they are a trade union member, or indeed because specifically they're not a trade union member. There is no minimum service period, so they don't need 2 years service in order to bring that claim. It's also automatically unfair to dismiss an individual because they are carrying out activities of a trade union where those activities are performed at an appropriate time. Again, there's a lot of detail, of course, around what are activities. Strike action would not be activities, but attending perhaps trade union's annual conference might be activities. But then the activities also have to be carried out at an appropriate time, and generally that would not be in work time where we're talking about activities. I'll come on to duties in just a moment, but where they're just activities, generally speaking, they'll need to be carried out outside of working hours, unless, of course, the collective agreement says otherwise. And that's, again, an area which trade unions will often seek to push on. It will also be automatically unfair to dismiss an employee. They might not have 2 years service, where we do a redundancy selection exercise, and the selection exercise essentially says, well, we'll pick those people who are trade union members, or indeed we'll pick those who are not, because then we won't get a hard time from the trade union if we pick the non-members. And finally, the one just to be a bit, which is slightly more, as it were, hidden, is where perhaps you have an individual who is an officer of the trade union. Maybe they are the local representative, rather. Perhaps they spend 50% of their time on union matters and 50% of time, as it were, on work matters. If then you look at their output and say, well, they're only producing half as much as the worker next to them, well, the answer is that's, of course, because they spend half the time. But if you don't take that into account, rather as one would be looking at a part-time worker, then it will almost certainly be automatically unfair to dismiss them, because we make an assessment of their performance as being poor and below par. Interim relief, so this is just briefly, again, it's probably something I'd suggest that probably even between Will, Stephen and I, it's probably fingers of two hands in between us, probably about 70 years of employment law advice, an application for interim relief. This is where somebody claims that they have been unfairly dismissed, automatically unfairly dismissed, on one of the bases I've just been describing. There's basically a fast track approach whereby on short notice, there's a hearing, preliminary hearing before an employment tribunal. And if the employment tribunal considers that there is potential merit to the case, they can make an interim order. And that interim order essentially is for the employment to continue. It is of limited effect because the tribunal can't force the employer to allow the employee back onto their premises, but to the extent that the employment is continuing, the employment relationship is otherwise technically still alive. Of course, the individual carries on being paid, and while they're waiting for their tribunal, substantive tribunal claim to be heard, as I say, they carry on being paid and receive benefits in the normal way. If we then look at action short of dismissal, and it's a little bit like, as Will said earlier on, we have strikes and then we have action short of a strike. We've got dismissal and action short of dismissal. So no worker should be subject as an individual, that's as opposed to as a group, as a class, to a detriment, a term that we're broadly familiar with, I'm sure, in the context of Discrimination and the Equality Act. That's, in this context, it's an action or an act, deliberate failure to act by the employer, where the act is for the purpose of either preventing or deterring membership of a trade union, compelling membership of a trade union. You're getting the feel of it now. It's both to not require people to become trade union members or to penalise them because they are, or where the detriment amounts to it's caused because the employer is trying to prevent or deter participation in the activities of an independent trade union at an appropriate time, or preventing an individual from using the services of a trade union at an appropriate time. We then talk about dismissal in the context of industrial action, and it's fair to say, I mean, so much of this area is unfortunately horribly statute-based and complex with lots of double negatives. I think that's one of the things when you're looking at this area of the law. And we are going to go into this in more detail in our next webinar in November. But just for now, there are probably four broad situations. So an individual might be dismissed in connection with industrial action, perhaps where there is lawful official action being taken. That's where the trade union has properly notified the employer, balloted its members, given notice to the employer, and individuals are then taking industrial action, whatever form that may take. Now, even in that context, an employer can potentially dismiss those employees who are taking part in that action, but it has to be incredibly careful. And essentially, it's subject to certain quite stringent conditions, broadly relating to the timing of the action that the employer takes and the procedural steps that it takes, not least usually involving ACAS. Second area is where there's unlawful action. Now, this is unlawful action is where a trade union has perhaps has created the unlawfulness, going back to what Stephen was saying, and the trade union's lost its immunity from action, from a claim against it. And that most commonly would be because they've not given advance notice to the employer of the ballot, not carried out the ballot properly, it perhaps hasn't been a secret ballot, then hasn't again given proper notice to the employer of days on which the industrial action is to take. Now, in that context, that's considered unlawful action because it's not been done properly, not been convened or coordinated properly by the trade union. Trade union loses its immunity, but also the individual employee has very, very little protection. The main protection, however, is that whilst the employer can sack all of the employees carrying out that unlawful action, what it mustn't do is what's termed picking and choosing. So it mustn't say, well, we still quite like that individual, so we'd like to have them. That person's been a pain in the neck historically, so we'll pick them. It's pretty much an all or nothing. So it's obviously quite extreme. And again, there are certain statutory provisions and conditions that apply. We then look at unofficial action. Well, this is where a trade union hasn't sought to call it. It's maybe in old money, in the old language, what I think Stephen referred to earlier as the wildcat strikes of the late 60s and 70s, and that was where there was just perhaps a local decision, maybe just even within an employer by a group of employees that they were going to down tools. That would be unofficial action because it's not action that the trade union has sought to call. It's not therefore unlawful action, so the trade union, as it were, isn't in the frame. The employee is very much out there on their own, and therefore in that context, the employee who is taking that action has no right to claim unfair dismissal. But an employer, and an employer can also, in that context, decide to pick and choose. And usually that's because the employer is trying to establish which of the employees were actually taking unofficial action and perhaps which were just staying at home and ringing in sick because it was all too difficult to as it were cross the paths of their employee colleagues. And then finally, at this high level, we've got lockouts. Well, that's essentially where the employer says, you're taking industrial action, well, you know what you can do. So they literally lock the employees out and don't let them attend the workplace. Now, in that context, the employees can't claim unfair dismissal unless they can show that the employer has been picking or choosing. So, as I say, we'll go into more detail on that in the next webinar, but it's hopefully helpful just to understand and identify those different categories. Now, where we've got an individual who's an official, maybe of the trade union, maybe the local representative, they're entitled to time off with pay for trade union duties where the work relates to negotiations with the employer in connection with collective bargaining, the performance on behalf of other employees in respect of matters agreed by the employer, or the receipt of information from the employer and consultations regarding redundancy and 2P transfers. And you'll see that in this area, as indeed in what I've just been talking about previously, many of these rights are irrespective of whether or not the trade union is formally recognised by the employer for the purpose of collective bargaining. So again, it's understanding that even if you don't recognise, I often get this question, but we don't recognise a trade union. Well, you may well not, but a lot of these rights are freestanding individual employment rights. Obviously, the first of those there, negotiations in connection with collective bargaining, it's less likely that that will arise if you don't recognise a trade union for the purpose of collective bargaining, but the others might still arise. So you might have a trade union member, they may be the local rep, they may be designated local rep, and they will still have protection and they'll be entitled to time off and time off with pay. Then if we're talking about activities, remember earlier on I was talking about activities and contrasting activities and duties. The distinction essentially is that time off for activities is generally unpaid, but it's potentially for a broader range of duties. Now, that classically that would be the activities of the trade union, albeit that's relatively narrowly defined. So, for example, going and joining a march to Parliament wouldn't generally be considered to be an activity of the trade union, even though perhaps it's been organised by the trade union. Similarly, an activity where the employee is acting as a representative of the trade union in some way, perhaps going to an annual conference. But it's right to flag that this is an area which, in the context of collective bargaining, trade unions will often seek an extension to build on the statutory protection. So the statutory protection is to allow a certain amount of time off, but unpaid. So classically, the union will say, well, we want more time off and we want it to be with pay. And then finally, in this section, a more recently introduced area, time off from work for the trade union learning representatives. This is probably a relatively innocuous one from an employer's point of view. And again, and indeed, it's probably one which will benefit some employers. So where you have a trade union learning representative, who's basically somebody who's supposed to work with the employer to help identify the training and development needs of employees, those individuals are allowed time off with pay where they're undertaking those activities that are on the bullets on the slide there. I think just rounding off, then there's one just about check off on political funds. And the key here is that it will very often be the case that the employer will agree, either through the collective bargaining or as a standalone, that they will administer check-off arrangements. Check-off is essentially a means of deducting from pay at source for the trade union subscriptions and possibly payment to the trade union political fund. Employers tend to kind of like doing that because it gives them a sense as to who's in the trade union. Of course, the employee may make private arrangements, so the employer doesn't do it and therefore won't know. But the important thing is the employer also needs to make sure that the deductions, or the fact that the deduction will take place, is agreed by the worker in advance, because it's subject otherwise to the usual restrictions around unlawful deductions. And as I say there on the final bullet, if the trade union member considers that the employer's got the calculation wrong, they can bring a claim for unlawful deduction against the employer. And again, as I say, that's an example of a right which is irrespective of whether or not the employer recognises the trade union. So we've just run over past. Don't know how we're doing on questions. Will, I think we have a couple.
Yeah, just picking up one quick one that I've seen, just sort of quick and easy to answer, is been asked. Are you allowed to ask the trade union for details of the members so you can work out the numbers? The short answer to that is there's no harm in asking a union for details of numbers, and as Stephen mentioned earlier on, indeed, if it becomes part of the formal process, they will need to satisfy the CAC about membership numbers and so forth. So you may well get some success in getting the raw data in terms of numbers. I suspect you'll have a lot less success if you were to ask a union to give you a list of your employees, who are their members. Aside from anything else, trade union membership is, again, there's data protection reasons, and trade union membership is classified as being a special category of data that has special protection to it. So I'd be very surprised if the union were to hand you a list of names of individuals, but likely to give you at least the raw data in terms of numbers.
Brilliant, thanks, Will. Well, we have got a few more questions that have been asked. So what we'll do as usual is we'll circulate to those that have attended, we'll circulate a list of those cues and our best attempts at the answers as well. So just run over time. Thank you all very much for joining today. Just a reminder that the next webinar, I think, is on the 10th of November. Please put that obviously in the diary. We'll send out more details of that shortly. But thank you all, as I say, for joining. Thanks to my colleagues, both on screen and those behind the screen, for their support today. And hopefully we'll see you all soon. Cheerio.